Alberta has recently amended the rules of court to introduce a process called a streamlined trial. This process is intended to create a more timely and efficient method of resolving disputes without the need of a regular trial. Now, this is not a new concept. Many other jurisdictions have a streamlined process for resolving certain types of claims. In fact, Alberta had a process referred to as a summary trial for a number of years, but this was rarely used by litigants because it was whether you would obtain a judgment at the end of the summary trial process. After lengthy consultations, the Alberta Rules of Court were amended to create this streamlined trial process, which is intended to be a more proportionate, timely, and affordable method for resolving certain types of claims. Streamlined trials are intended to resolve claims that may not be appropriate for summary judgment, but do not require the significant cost and time of a regular trial. Importantly, a streamlined trial is still a trial on the merits, and the presiding judge is required to grant judgment at the conclusion of the streamlined trial. Now, the introduction of the streamlined trial process is an example of the efforts that are being taken to create a more efficient and cost-effective dispute resolution process in the courts, a process that will actually be used by the litigants. This is intended to address the delays in the courts by allowing certain matters to proceed through to trial on a more expedited basis. It will hopefully allow some parties involved in litigation to avoid what has become a lengthy court process and have their matters determined by a judge in a more timely, cost-effective manner. The hope is that streamlined trials will help clear the backlogs in the court and ultimately bring about greater access to justice.